Welcome to Self-Represented in Family Court. Your host, Tracy B. That's me. So, here we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Hello, I'm back. It's me, Tracy B., the family court strategist from the Divorce Solutionist. And you're listening to Self-Represented in Family Court. Well, I hope you had a nice, long, and very, very fun-filled summer, because I certainly did. Oh my goodness, summer is my favorite time of the year, and so I make sure I just take it and eat it all up. And this summer was no different. But I did miss you. Yes, I sure did. I missed coming to speak to you, to let you know what's going on in the world of family court from a strategic perspective, of course. And today is episode 1 of season 2. Woohoo! Yes, I'm back for season 2. And so today I wanted to talk to you about a topic that comes up quite often, very, very often, when I'm talking to pro se litigants especially, but when I'm talking to family court litigants overall. And that is perjury. Yes, perjury. This topic comes up so much that I actually did a blog about it. And I'm going to include the link in the show notes for the blog. But anyway, so much has happened since I did that blog. I've learned so much about pro se litigants and their perspective and your needs and everything. And so I'm always learning and evolving and growing and changing and transforming. And because of that, I'm always doing the same thing with my content that I put out there. And perjury in family court never gets old. I always have a different perspective on a lot of these topics. And so, yeah, that's another reason why I bring them up often. But today specifically, I wanted to bring it up because recently someone asked me to do an episode on the topic. And so today, that's what I'm talking about. So perjury. Perjury, what is perjury? Perjury is actually knowingly lying, particularly under oath. Perjury is when you are either sworn in to speak the truth, or whether it's in person, or you sign an affidavit or an affirmation affirming that you're telling the truth, and you intentionally lie. You intentionally deceive. You intentionally make things up. Or, shall I say, embellish things a little bit. Now, I'm not going to lie. Anybody who knows me knows as a strategist, I'm all for tailoring the truth. But that depends on where. If you're under oath, you're under oath. And you should be actually telling the truth at all times. Not because you're going to go to jail for it, because even though perjury is a crime in every single state, is a crime that is rarely ever punishable. But in a lot of instances, when it is punishable, it's usually in a criminal court action or beyond, where whomever has that authority will use it as a silver bullet or some leverage to get the other party or defendant to do exactly what they want them to do. But in family court, it's rarely ever punished. Even though it's a crime, family court judges do not have the authority to prosecute crimes. They can refer cases to the district attorney or the AGO, whatever it is in your state, and leave it up to them, because the prosecutor in every single state in this country has the discretion to pursue crimes. The cops have a discretion to arrest. The prosecutor has discretion to pursue or prosecute, and judges have discretion to sentence once all those other two elements are met. So when you're talking about perjury, even though the laws are on the books in the penal codes, actually delineating it as a crime, whether it be a misdemeanor or a felony, the reality is it's not a crime that is punishable or pursued or prosecuted from a family court's perspective, in any court, really, honestly. And even in courts where it is pursued, it's rarely ever gotten to the point where anyone has actually gone to jail for perjury. Um, that's because that's because that's because to prosecute a crime costs money. It costs resources. It's time consuming. And sometimes the benefits of prosecuting a crime, such as perjury, is outweighed by the costs. And so it's not that it's not ever punishable. It's just that it's rarely ever punished, especially in family court. Now, in other courts, maybe. And again, a lot of times when it's done, it's usually done as a overall scheme or overall strategy of the whomever the pursuer is. So yeah, it's not like it's never punishable. It's just that it's rarely done, again, especially in family court. However, there are other uses for pursuing perjury. And as you know, I'm a strategist, so for me, everything has a use. Everything, even though the judge may not actually act on something, sometimes just mentioning it or having that leverage is enough for a different part of your case or a different aspect of your family court case. And so perjury, although may not be something the judge is really interested in pursuing, it might serve another purpose. And let me give you a very good example. You may have a case where the other party has perjured him or herself several times throughout the course of your litigation, and your case is going to actually go to trial. So now that person, that party, is going to be a witness and they're going to testify at trial. And so now you have all of these instances where they were lying, basically, or perjured themselves, and you didn't have any success with the judge actually pursuing that or prosecuting them for it or referring them to the DA's office. Now you can use it to prove to the court why that witness or that party should not be believable, should not be credible. So that when they're testifying, everything they say basically should be not believed, should be shot down, because you've uncovered, discovered, revealed certain instances in the previous court appearances or at some stage throughout your case, throughout your litigation, where they've lied, whether that be on paper, whether that be in court, wherever it is, or in depositions, wherever it is. Even in outside proceedings that have nothing to do with court, and they were under oath and they testified something and it's relevant to your court case, and you uncovered the fact that they were lying, again, you can bring those things up. You may be able to bring those things up to prove that this person lacks credibility. In other words, basically they're unbelievable when they're testifying, and that's a crucial thing, because that's part of one of your main goals at trial is to impeach the other party's witnesses, to make those witnesses, including that party, reveal it to the court or make your case to the court that they are not worth believing. Because if that's all they have is their testimony and other witnesses' testimony, and they're found to be unbelievable, then that basically minimizes or compromises their whole case. So in that instance, yeah, you can do it. And in other instances outside of court, you can use perjured information, like in other hearings, other proceedings. There are other proceedings, disciplinary proceedings, CPS proceedings, criminal court proceedings. You may have hearings at school for your children. I mean, in actually almost anything. Other courts, housing court, bankruptcy court, whatever it is. So you may be able to use that. It's not that it's completely useless. It's just that it may not be punishable in family court. And it may not be as directly impactful in family court as you'd like it to be, or as a lot of litigants would like it to be. So it may have limitations in that respect, but again, it may have some other uses. And anytime you have the opportunity to basically identify weaknesses, what I call weaknesses of the other party's case, of the other party's facts or backgrounds, there's always a use for it. I'm a strategist. There's always a use for everything. There's always a use. That's your job, though. Your job is to figure out how to use that. Just because something is illegal or illicit or unlawful or unallowed, it doesn't mean it's useless. It doesn't necessarily mean it's useless. It means find another use for it. But don't expect the judge to really get interested in the fact that you've uncovered or revealed that the other party has perjured him or herself. And even some judges, I can't speak for all judges, but even some judges will admonish, they may admonish that party. They may use that against that party, and when they're requesting something, and the judge is not pleased at the fact that they've perjured themselves several times, so the judge may deny their request. The judge may look at them unfavorably. The judge may hold that against them, and use that against them in some way. So it's not that it's completely useless. It's just that it's not necessarily punishable or prosecuted in family court. Perjury, it's not. When it is, there are states where perjury is actually a felony, but in the states that it is a felony, it's usually a low class felony. So what that means is a lot of times it's low class felonies are punishable maybe by probation. Felony probation in some states is 5 years, in some states it's more, some it's less. So it's usually probation. It might be some services, some monetary remuneration. It may be all of those things. So again, it depends. And in the states where it's actually a misdemeanor, misdemeanors are usually punishable by up to 1 year in jail. Probation, some places have misdemeanor probation, community services, programs. Again, some monetary and sanctions imposed on them. So whether it's a misdemeanor or a felony doesn't really matter that much from the family court's perspective. It might matter to you if you really want to pursue that with the DA's office yourself directly. And good luck with that, because trying to get the DA to pursue a crime or prosecute a crime that, number one, the police didn't want to arrest for, or number two, the DA is known or has a history of not prosecuting that crime, is really difficult. And if you're pro se, your chances of getting a prosecutor to prosecute someone for perjury is on your own is slim. You might have a little bit more luck if you have an attorney that represent you, and the attorney has a relationship with the prosecutor's office or have some sort of influence, and they can get the prosecutor to actually prosecute perjury. And then you may have even more luck if you have, if you're in an area where your politicians, whether that's your council person, your whatever it is, and they're a little bit more involved and proactive and effective in getting the district attorney to actually do that. And sometimes that is, doable, because sometimes their local politicians have relationships with prosecutors too. They're all, most of the time, they're all connected in some way. They all support each other, and or not, depending on which side of the political fence they're on. But they usually have some sort of affiliation, and they usually travel in similar circles, if not the same circles. So, but it all depends. But the bottom line is, if the judge doesn't refer, or some other key player in the courtroom, because other key players can also refer, the guardian ad litem, mediator, parent coordinator. Again, it depends on your local procedural rules, but they may be able to refer, or they may be able to, start the ball rolling to refer. that the other party be prosecuted for crimes. Again, everything about prosecuting for perjury is entirely up to the district attorney or the prosecutor's office or the AG's office, whatever, whomever that actual official is in your area. It's entirely up to them. It doesn't matter who refers. So it's still, at the end of the day, it's their call. So, and again, it's depending on who it is that's actually involved in trying to get the prosecutor to prosecute, may be a little bit more effective than others, especially if you're pro se. If you're pro se and you go to the DA's office and you say, hey, listen, I want this other party prosecuted for perjury because they've perjured themselves over and over again. And I just want you to, I've never seen an instance where a pro se litigant was able to actually effectively do that on their own. And again, nothing is impossible. Anything is possible. So, I am the last person to say what will never happen, but I've never seen it happen or heard it happen. So, again, good luck with that. But perjury, yes, perjury is something that a lot of people get distracted over. Like and I get it. Culturally speaking, some people have religious values and beliefs, or just, values and beliefs, period, that are antithetical to someone actually blatantly lying, especially under oath. And so some litigants really take offense to that, and they would really like to see the other party punished for that. But, it's a red herring to me. I'm often advising people to let it go. Like if they're, so stuck and, hooked on actually pursuing perjury and punishing the other party, I actually often recommend that they use it for other means, other methods, other parts of their case. They use it in other ways, because sometimes getting so caught up on trying to prosecute the other party for something like perjury can actually derail you and sort of dissipate any other strong argument you might have for anything else. It's not going to make your case stronger because you've identified the other party being a habitual liar. It's not. If your case is strong because you are more quote unquote fit, if you're in a custody battle, then that's what your case is relying on. If you can tie the perjury into something that has to do with the best interest of the child factors or any other law that applies to your case, then so be it. But to expect the judge to really get adamant and firm on punishing or penalizing perjurer, I would not. I would move on. I would. Again, part of being strategic means just because you could doesn't mean you should. Every little thing that you identify that's wrong or that's compromised or that's a weakness or, it's not worth addressing. It's not worth giving your attention to. And I am a strong believer in you conserving your energy and your attention and your resources for things that really matter. What really matters in your case is determined and dictated by your judge. Your judge is the one controlling, what happens, what the end result is going to be at the end of the day. So if I were you, if your judge is not moved by the fact that the other party perjured him or herself, then again, I would not insist that the judge do something. If your judge made it clear that they're not really moved by that, then move on, let it go. That's the case with anything, because a lot of people will go to court and think that they have a slam dunk case. And when I look at it, I'm like, you don't have a slam dunk case. What you think is slam dunk is because you're focusing on things that the court doesn't care about. Right? And that's what a lot of pro se litigants, that's their biggest faux pas, is that they'll think they have all of these silver bullets and these magic bullets and they have evidence that's going to prove and then I look at the evidence. Number one, it's not evidence. It's just information they gathered because it might be illegal or it might be, gained unlawfully. But a lot of times it's irrelevant. The evidence that they have is irrelevant. Or someone will come to me and say, hey, the judge didn't look at my evidence. And I look at the evidence and I'm like, I see why. It has nothing to do with the issues at hand. These are issues to you. Issues to you are not important. Unfortunately, the issues that the judge think is important is what's important. That's what your evidence needs to correlate to. And the same thing with perjury. If your judge is not, a big anti-perjurer or anti-liar or anti-whatever it is, I'm just making up words. But if your judge is not really that moved or taken aback by someone perjuring themselves, and whether they are or aren't is no concern of mine. I don't care either way, because at the end of the day, it has very little to do with the substance of your case. And that's what I want you to focus on and remember as well. So, anyway, that's all I have for today. I also wanted to start something new where someone had asked me to do add a little Tracyism at the end of each episode. And if you know me, if you've been following me from day one, you know that I have quite a few Tracyisms. Yeah, I make up words all the time. So for this week, the one that has been one of my original ones that I've been, using since I started doing strategy work, and that is focus on your truths and not on their lies. And what that means is some people are really, really thrown off, really derailed and distracted by the other party's allegations of whatever it is that are false, that are lies, that are deceptive, that are, made up, that fallacies, they're all kinds of things. And so they will come to me and they're really laser focused. They're really hyper focused on all these lies that are in a petition or affidavits or that they said in court. And I'm always reminding them that they don't need to focus so much on those lies. But one of the main reasons is because what I just said. What is it going to do? Now, you can use it later, but to hyper focus on them and to go to court and want to address each one of the lies, to me, a good portion of the time, it's a waste of time. You want to focus on your truth. A lot of times when you're telling it, it's much easier to tell the truth than it is to try to defend a lie. To defend a lie can take so much work, so much effort, so much energy. It's much easier because you have to anticipate the lies and the source and, the motivation. And it's telling the truth doesn't even require all of that. It just merely requires you to go in court and just start, spewing the truth. So, and it's much more, judges are not stupid. They're not stupid. They know who's telling the lies and who's telling the truth. And sometimes, yes, they do believe the lies. But a lot of times it's because you're so busy focusing on the lies, the judge gets the impression that you don't have any truths. You don't have any truths because if you did, you'd rather do that than to waste your time focusing on lies. So that's my Tracyism for the day. Focus more on your truths than their lies. And I guarantee you that you'll not only get, much further ahead, but you'll feel better because you'll learn how to allocate your energy, your time, your resources to things that really matter, to things that are really going to get the court's attention, and to things that's really going to get the court to do something that you are actually asking them to do. All right. So thank you so much for tuning in. I wanted to also mention that I recently started accepting podcast guests. And if you are interested in signing up to be a guest, please let me know. Feel free to send me an email at tracy@thedivorcesolutionist.com and put in the subject header podcast guests, and I will send you over the form. What I'm looking for are people who are actually, I would prefer people who are actually pro se, self-represented, and they're actually in court or just finished court, and they want to talk about their case and different strategic moves they could have made. Yes, it's almost like doing a live strategy session on the podcast. Now, we will use pseudonyms because we don't want to get anybody in trouble, and we can actually pre-record it and actually record it after we edit and cut out whatever it is you don't want to reveal. But please, and it's usually going to be somewhere between 20 and 30 minutes. We won't let it go over that. If it does, we'll actually have to edit it. But I'm looking for people who are open and willing to discuss only divorce or custody cases in this country, United States, and only for pro se litigants people who actually represented themselves for the most of the time that their case was pending, and definitely toward, if your case is over, if you represented yourself at the end, that would be ideal. When you got the final order, the final decision, that you were pro se, that would be ideal. And that's the only criteria. And you're open to doing, a strategy session with me, and having it aired. Again, we'll use pseudonyms so we don't get you all jammed up in court. But yeah, so I would appreciate anyone. And also, I'm open to topics. If you have topic recommendations, please feel free to let me know about that as well. And the last thing is, I just started a subscription based podcast where you will get premium content for, if you pay the monthly subscription fee. That premium content will be, I will take specific questions that you have, and I will answer them in exclusive episodes, podcast episodes. I will share worksheets with you, workbooks, PDF e-guides, and anything else I have that I actually use with my clients. So feel free to inquire about that. Any inquiries about the podcast, about my services, feel free to email me at tracy@thedivorcesolutionist.com, and I will get back to you as soon as I can. We want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.